Hey, good afternoon. Hope everybody's having a wonderful Monday before the Independence Day holiday. Something came up in the practice today, and it reminded me to speak a little bit about liberty and how liberty can be constrained or determined by court order. This is a scenario that came up in a colleague's practice, but it's equally applicable to things that we do here. And one of those issues was there was a court ordering a parent to bring a child back to Texas, and in fact to move back to Texas. That is going to be a serious restraint on that parent's liberty, and if that parent doesn't comply with that court order or challenge that court order can be enforced by contempt and even criminal action, which means that this court could issue an order and a warrant to grab that parent, put that parent behind bars in that state, return the child to the state of Texas to the other parent. And so the court has a lot of authority to restrain liberty if a party doesn't comply with the court's orders. So what do you do in that scenario? You don't want to contest the court's order in a non-legal way, in other words, by disobeying it, because that's what opens you up to the court's contempt authority, a restraint on your liberty. So that's not an option. What you need to do is you need to quickly assess what is the scope of that order, what is it requiring you to do or not do, and then what legal advice can you get if you want to continue to challenge that or further challenge that. And how do you do that? Well, you do that by filing a notice of appeal, consulting with an appellate lawyer, and bringing an appeal. You punt to the higher court and say, Judge, my rights are being not recognized here, or were recognized incorrectly, and I'm appealing to the Court of Appeals for some relief. And do you need to bring an emergency motion for relief? Well, if the court order from the lower court is requiring immediate action, you may need to bring more than just an appeal, because an appeal puts it into we call it appellate orbit. It could be 12 to 24 months before you get a ruling, and that may not be fast enough. So there are remedies out there, and the point is, when your liberty's at risk, when you're under compulsion by a court order to do something, if you've got an appellate remedy, figure out what it is quick, and don't sit on your rights. Don't wait until day 29 to hire an appellate lawyer and file a motion for rehearing, reconsideration, notice of appeal, because if you need emergency relief, the sooner you act, the better it is. It's just like anything in life, being proactive and showing up. Anyway, hope this has been of some help. Everybody have a wonderful and blessed holiday week.